I couldn't do that. And last but not least, HCD, California Department of Housing and Community Development, Division of Codes and Standards. That's really easy to say, right? So that's going to go to you, Sal. All right, so with that, thank you for my little commercial there. I just really wanted to thank these guys. I really appreciate them. So with that, we're going to get started. I have some questions up here. The first one I have is that it says, when is the HCD going to get funding in order for them to enforce the MRL laws in mobile home parks? They keep saying they can't help us as they should because they don't have enough money. So I don't know who wants to answer that, but it was really more my question because it's up to us as a legislature. And I will tell you that I had a bill this year that would have helped with that, but it did not get, it's dead. So we will keep trying. Thank you very much. We will keep trying because I do understand that part of the challenge for HCD is that they don't have the money to do everything that needs to be done. So that is part of my plan to help them get more money. So I will keep trying. All right, next question. My ex-wife applied for lost title, and she was not the owner. Who pays all the money that is lost in attorneys and bonding and court costs? And where can I go to get my money? And he's got his address here from Riverside. Who would like to try that one? Thanks, Sal. We only have one microphone, I'm sorry. You guys keep it, I'm pretty loud.
Yes, I'm not the registration titling expert on this, but if you visit our website at www.hcd.ca.gov, you can go into our registration titling program, and all the forms are available on that website that you can download. You can also contact our Riverside office, registration and titling, 951-782-4437. And they'll be able to assist you in all the registration and titling questions that you may have.
I'm sorry, is it hard to hear? Louder, yeah. Okay, we are turning up the volume right now. Do you want to repeat that, Sal? Thank you.
For any of your registration and titling questions that you may have, I'm going to give you our website so you can go into it. And you can download all the forms. We have a list of frequently asked questions, and those questions are listed on our website. And you can go into it at www.hcd.ca.gov, or you can call our registration and titling office in Riverside at area code 951-782-4437.
That's me. Unfortunately, it's me.
Okay.
Okay? I'll explain the situation. My ex-wife, I was in Nevada. I let her stay in my sister's home, which is the mobile home, now that I live there. So she was living there for 4 years. Free, she was just living free. I was paying the mobile home loan. And she went to the housing authority and claimed lost title. That issue. Your office gave her a title without me knowing anything. All my sisters that she used to own that property. All she did was forge the signature, add my name in it, and forge my signature too. And I can provide all that signatures to you. I went to your office, to the claim department, no questions asked. Okay? All she did was get a bond and transfer all the titles to her name. That's unbelievable.
So if I can jump in here, what I would suggest is that you speak with Stephanie Reed, who is at the doorway there. Miss Stephanie, raise your hand. Stephanie, raise your hand. You don't have to come up here. I'm going to have this gentleman speak with you because she has helped other people with their title, and this is what she does full time every day. So that way we get to everybody's questions. I want you to speak directly with her.
all I want to say, they got to be more difficult, more restrained, more strict, like giving your driver's license or a couple more IDs to transfer these things, because you know what? Anybody can do that.
Yeah.
Okay?
No, we hear you.
And I spent $7,000 to do this.
Yeah, that's
to
a lot.
transfer to my name. Okay? All lawyers know that. Huh? My city. I can give you all the proof, the lawyers and everything. I went through.
Stephanie can help you. The thing for all of you that are sitting here, one of the biggest problems about transferring titles, even for us as the owners of property, a lot of the taxes are not being paid on these houses, and they accumulate, and then the titles go 2 and 3 generations, and they don't get transferred. And so what has to happen, I mean, and we work with HCD too, and they put us through the ringer probably more so than you, because we're park owners and they don't want us to give away your title to us as an example. But again, understand they only can go with what they see in front of them, and I'm guaranteeing that she probably did show them some kind of ID. They're really strict about what they do at those counters and how they transfer title. It just doesn't happen. They don't give away your homes.
Oh, they do. They do. They do.
All right, and we'll have you speak with Stephanie also, okay?
They do.
All right, so the next question is more funding for HCD, how soon? Great question. If I've learned nothing in the last year and a half, I've learned that government moves slowly. But there are things that HCD can do now, right, Sal? It's just, they're not sitting on their hands doing nothing. More funding would help for everyone. Let me keep going. Fight these predators who are raising our rents, increasing our utilities so high that we can't afford our monthly payments, then evictions. Why can't HCD get Sierra to maintain our park in a timely manner? Nothing is being repaired or fixed.
As you know, the Mobile Home Park Maintenance Inspection Program under Senate Bill 951, which was pushed through Senator Leyva, that bill sunsets January 9, 2019. What that bill requires is HCD to inspect at least 5% of mobile home parks in the state of California. Basically, northern part of the state, they'll do the 2.5%, and my office in Riverside, we do 2.5%. And so that basically equates about 113 park inspections that we do annually. Over the years, the bill that mandated the state to inspect all the mobile home parks has been amended many times, and we're down to where we were required to categorize the different type of violations that we were going to pursue. We're only going to pursue 2 types of violations. One was violations that constitute an immediate threat to health and safety, and then the other is violations that constitute an unreasonable risk to health and safety. And so those are the 2 category type of violations that we were pursued. Now, there are other violations that are considered technical in nature. We don't pursue those at all. But we are inspecting the parks, and so far this year we've inspected 138 mobile home parks here in Southern California. We've cited thousands of violations so far. Violations against park owners, we're at almost 5,000 violations that we've cited against the park owners as their responsibility to correct. And residents, we're almost at 10,000 so far this year. So we have the remainder of the year to complete our 5%. I believe we're going to exceed our 5%. And so we are inspecting all the parks. Just last year, we inspected all the parks in the city of Pomona, and we cited thousands of violations. But we're out there, we're active, we're proactive, and that's the program at this point. So.
You have a list of them all parks?
Yeah, we have a list of all the parks.
How can we get this stuff?
You can go onto our site, again, www.hcd.ca.gov, and go into the mobile home park, special occupancy park listing, and you can You'll see the entire list of mobile home parks. You can go ahead and sort it by the county or by the city, by the name or the park ID.
These guys get, been up violations. Do they have to pay these guys any kind of fee? Like $2,000 a month?
Yeah, unfortunately, and I thank Senator Leyva. She introduced the bill, Senate Bill 1106, which didn't go too far, but she made an attempt, and we're going to revisit that again. But it's given the HCD citation authority, and I believe the criteria was $100 per violation, and if it happened again, it was $250 per violation. But at this point, we don't have any citation authority. We issue notices of violations and not citations. The notices of violation giving the park or the resident 60 days to comply to correct the violation.
Isn't that kind of small amount of money for the owners to pay for a violation? It should be up in the hundreds.
I'll ask that. The reason we did it that way is because this also applies to residents. So we are concerned that the residents don't want to break them as well. But the bill did not pass, so we're going to be bringing it back next year. So if you have some suggestions on what you think as a resident would give it more teeth, please let me know. I would love to hear that.
Yeah, on the other one,
So we try to stick to the questions. Is this on this?
Yeah, question.
Okay.
this is a violation of the joint law of the MRL. It's a $2,000 fine. You go to small claims. That was amended years ago during the mom and pop park days. Now that 2,000 should be 5,000 now. Are you familiar with that one section?
It's a different section.
Okay.
That's a different issue.
It's a different issue.
Yeah, we don't have citation authority. The only monetary civil penalties that we would impose is if, for instance, if the park owner didn't comply with the notice of violation within 60 days or 30 days, that we would file a case with the district attorney's office for prosecution. Now, the district attorney may assess civil penalties, and those penalties are $500 for each violation and for each day of continuing violation. So, after 60 days, the violation continues at $500 per violation. That amounts up to a lot.
Are they pursuing that?
Yes. Oh, yeah, and we file legal cases on an everyday basis all over California.
And then there are thousands and thousands of mobile home parks up and down the state. So sometimes what I was trying to say is that we're pursuing them, they are pursuing them up and down the state. We just don't always see it in our own backyard. So just if we don't see it in our own backyard, doesn't mean it's not happening.
Now, there's a wall in Hometown America, there's coming down. Did you check that already?
Sir, let's save that for when you have some time to talk to him privately. Let's let Mr. Heater answer this question also.
Yeah, I was going to add to what Saul was talking about. There's actually two bodies of law which control the maintenance of your park. Now, HCD is responsible only for enforcing what's called Title 25, the California Code of Regulations. And it contains a number of technical requirements relating to different issues in the park. Minimum water pressure, sewer problems, and that sort of thing. However, the mobile home residency law, this thing, has a provision in it that requires the park to maintain its physical improvements and common facilities in good working order and condition. That covers all maintenance problems. You are the enforcing person for the MRL. In other words, you can bring a civil suit under the mobile home residency law for failure to maintain the park. And in that suit, you can also enforce Title 25 as part of the lawsuit. And if you win, you get attorney's fees, you get damages, and if you can show that the park owner was willful in refusing to maintain the park, you can get the penalty that's specified too. And that penalty, though it's time probably to raise the amount of the penalty, can be significant, depending on the court ruling on what constitutes a violation. What if you have 50 people in the lawsuit, and there's one thing the park owner did wrong? Is that 50 violations? Or it's a continuing violation. It's a violation every day, $2,000 a day. So it can be significant depending on how the court interprets it, and there have been significant penalties awarded under a failure to maintain lawsuit under the MRL. And my firm's brochure is on the table, the blue one, and you can read a lot about that kind of stuff there.
You should know who I am, right? I'm Paul Madsen, I'm in my suit, Roy Western Place.
Right. I know the park name.
Okay, cool. So my problem with that is you keep letting these guys off the hook, like some of the cases out in court. The point is, you keep letting these guys off the hook, we get no more but deeper and deeper into debt.
Well,
Until we take these guys straight to court, court is going straight to court, we ain't gonna solve our problem, doesn't maintain the park.
well, the legal system is not perfect, and so you're never going to. Let me just answer. You're not going to solve all your problems, you know, by going to court necessarily. You might get a better result at trial. You might get a worse result. Anytime you settle a case, it's because the client decides they're going to accept the settlement. So that's controlled by the client. But there's limits to what you can get by going to a court trial. Sometimes a court will order repairs, but they're usually reluctant to get involved in the operation of a park. Insurance companies settle lawsuits. They'll pay money, but they won't pay to fix things that are wrong with the insurance park, because that's not what insurance money's for. So the real problem is getting stuff fixed. The big stuff, usually if it's like a life-threatening or health-threatening situation, HCD can get it fixed. But other stuff is very difficult to use the legal system to get it fixed. So you get money as a substitute in damages. That's just the way it works. And it's slow, and it's expensive, and it's not perfect, yes.
Thank you. Thank you. All right, next question. How can we keep greedy corporations from coming into our town and buying up mobile home parks and raising rents every 90 days to the extent of renting the residents out of their homes? I think we need to keep greedy corporations out of everything, not just mobile home parks. So we'll keep it at that today. Who wants to tackle that one?
Greedy, okay. Definition of, I mean, one of the problems that you're always faced with is when you're living in rental property, it is an income stream that mobile home parks are based upon. And then when the large syndicators, like the ELSs or the Sun Americas, decide that they're going to buy portfolios, there's not a lot you can do about it. They come in, they make offers on properties based upon the current operation standards of it and what they think will take place over the next year. We have a major problem in California because of Prop 13, to be very truthful. Because Prop 13, there's been no property tax adjustments on many of these properties for 50 years or longer, to be very truthful. So what happens is when a property gets sold, the new price establishes where the property tax goes, and guess what? In most cases, that's a legitimate pass-through, whether it either is by rent control or by lease agreements that you may have with the current park owner.
It is. It's faded now.
Okay. So the problem that you're faced with is especially in California, where we're seeing lots of issues and the increase of major increases in the rent is over the issue of property tax. They've tried to pass some laws that are going to try and address issues in California where commercial properties are considered one way and individual properties are considered another. Be careful what you ask for, because if mobile home parks get set up as properties that are listed as commercial properties, then that pass-through is going to happen every year and every time. So one of the cautions that I would say is the biggest issue is property tax. Other corporations, like we were just involved in a transaction, we were involved in a transaction where 18 properties were sold and we were operating the better portfolio. Many of you know those properties, premium properties. The transition took place and we ran them for 18 months and there wasn't one issue that came up in regards to rents in those properties while we had them. The problem is now they've just been resold over behind our back. We didn't know it was coming. A company came in called Sun America, has just bought out that entire company called Carefree, and now they control those parks. I have no idea what they will do in regards to the rents in those communities. We're hoping that they will be as good as when Carefree bought them, but there's no guarantees of what they are going to look at and say, okay, well, our property taxes increased, or these are our costs. Again, the nice thing about that, in most of those cases, There were either leases in place in several of those communities, which will govern what they can do to you, and or there is rent control or rent accords, such as in Rancho Cucamonga, that we agreed to and signed on to when we were operating the park, so that they are obligated to live under those agreements. But there's not a lot you can do. These big corporations are the people that are coming in and buying. The only thing I can tell you is the nonprofits have been really successful in the state of California of being able to buy properties and being able to maintain a lower level of rents for you. It's involved in a couple of cities. We run several of the nonprofit properties, and so they're able to maintain, they're not in it to maximize their income. They are set, or they're set. You can make a 10% profit, and all the other money has to go right back into those properties. So it really is a good way for a lot of these parks if the nonprofits get involved and they buy the properties, and in a lot of cases they can pay as much as some of these big syndicators can, because they don't get hit with a huge property tax increase, because they look at the affordability of who lives in the communities, and they don't get hit with the full property tax increases. So if that's one of the things that fears, maybe you should be talking to some of the nonprofits to see if they might be interested in purchasing your communities.
I'd like to add, I mean, getting back to the real issue is rent increases, and unreasonably high rent increases. And the only solution is rent control. And that's rent control at the local level. There's no state rent control. There's nothing in the mobile home residency law that protects you against excessive rent. So it's either your city or your county, depending on where you live, that's going to have to enact rent control. And this idea that a new park owner coming in is paying a much higher price and that increases the property tax, well, sure, but then they need to adjust their purchase price to reflect the fact that they know they're going to have to pay a higher property tax. Under rent control, you can deal with those types of expectations and still guarantee the park owner a fair return. But again, the only solution is rent control. It's not a nonprofit coming in, because you never know who's going to buy your park. The current park owner may be a great park owner, and next thing you know, ELS has acquired your park and is jacking the rents up. So the only solution, the only protection you can get is rent control. If you can't get political relief at the local level, then you can try a voter initiative. That's the solution.
Tell me if this is wrong. What we've said in other meetings like this is if you're interested in rent control, this is something you do at your city council level, or as you said, at the county level. So a group of residents could band together and approach their city council. Is that the correct way to do it?
Right. I'd start with your county supervisor or your city council rep, and I see one lady shaking her head. Face it, I mean, it's political, right? Conservative city councils are anti-rent control, they're pro-property rights. Some cities are known to be pro-tenant, some are known to be pro-landlord. What I'm saying is that's the start. If you get a large number of people to sign a petition, they're sensitive to the fact that you're voters, okay? And you've got a lot more votes than some corporation that's in Chicago, okay? Number two, if that fails, you can always get a voter initiative passed and go over the heads of your city council. And that's the solution, where you have the city council just politically won't act. So those are the two ways of going about it. But the first way is to try it through local politicians.
Just something to add to everything that's been said already. Remember also that there is a provision of the Mobile Home Residency Law, 798.80, that requires the park owner to give notice to any resident organization in the park that's been formed for the purpose of receiving the notice of when the park's going to be sold. So it's important for every GSMOL chapter, every HOA, every group of residents to form that organization, and every year you give the contact information for that organization to the park owner. The park owner is supposed to let you know when the property is going on the market. Doesn't mean that you have a right of first refusal. Doesn't mean they have to sell the park to you, but we have a lot of materials on the GSMOL website. If you go there, our Vice President of Resident-Owned Communities, David Loop, has a whole package of information that we provide to our members. How to form the organization, how to give notice, all the documents are there. So I would also encourage you to.
Two cautions. One of them being is that that has to be done yearly. You can't just do it once and let it go by the wayside. So if you think you've done it, understand, do it yearly, okay? Because we've seen it happen several times. The other issue is sometimes, like an example of Sun Communities buying the Better portfolio recently, they bought out Carefree, the company. They didn't buy the mobile home parks. So that wouldn't have ever showed up anywhere, and there wouldn't have been any notice to the residents at all. I beg to differ a little with Henry in regards to, of course we're going to, in regards to long-term leases do have some protection for residents, and it's another way of having some rent control protection. The other issue, as I see it, because one of the problems that we have on an ongoing basis in rent control areas is the fact that we can go in, and we just had a 1974 mobile home in one of our communities sell for $735,000, okay? To me, that's them taking advantage of my ability that I could only raise the rent. It's $80 on that space that's on the ocean. And so, well, but again, it's the same thing. Put yourself in everybody else's shoes. Same thing that Henry makes a comment about increase on property taxes and those kind of issues. I would suggest that if you're sitting there and you're selling your home and you're not getting an increase, that you probably should get the same increase that a property owner did to put some parity to where we are in the values of houses.
But why get involved with mobile home parks? You put us down and make money. It doesn't make sense.
I agree. We're going to follow
Why these parks up? We're making too much money. That's not fair. You know, we're going to screw, but nothing.
On this question about the green park owners, go ahead.
Okay. We have been trying for several months, and we've addressed our city council several times.
What city?
Corona.
Okay.
And we've had 3 parks bought up, and they've practically rented everybody out of their homes. And the city council tells us we have to have 6,000 names on a petition before they will even consider putting that on an ordinance in a town. And what can we do in the meantime? Meantime, these people are being rented out of their homes. It's just not fair. What can we do?
Well, I think, as he said before, I mean, one of the things about 6,000, you probably have to have 6,000 registered voters for them to get it on the ballot. I'm suggesting that they're telling you that you need to get not only yourself, but you need to get the rest of the community behind you to get so they put it on the ballot and then make it an issue for whatever the local government is.
Okay,
I think the state of
doing that. But what do we do in the meantime?
Well, and again, but it's I think as Henry has stated to you, some of these things take time to get through the process, and you know, you got to be diligent at what you do and timely. I mean, one of the things about, you know, from my viewpoint, your viewpoint, we can have differences of opinion. The thing is, you know, at least the properties that we own and stuff, we make sure that we maintain the properties. One of the things that we see is the properties that aren't maintained, and that's part of the issue. And hopefully that the majority of people, you know, you are living in decent communities. We're finding, and the senator has found very honestly, that there's a bunch of properties that aren't very well maintained that we need to do something about. And, you know, we back her totally, totally.
Either one of our attorneys want to say anything?
City of Corona, Tim Sheehan, that's the one we've been involved in, correct? With the city attorney.
Yeah, we initially tried to get a moratorium.
Right. I mean, the process is as follows, in my opinion, and the passion that you are displaying here today at the meeting, I trust has been displayed by you and many others in front of your city council as well. Because that obviously is a starting point. I always say, find an ally on the council, go to that ally, educate the ally, give them the facts, and begin to develop a consensus on your board of supervisors or your city council about how important it is to maintain mobile home, manufactured home, affordable housing. In your particular jurisdiction, which is Orange County or nearby, and is a very conservative area of the state, we know from the lack of ordinances, rent ordinances in this area, that it has not been a good sell over the last three or 3.5 decades. That's why the City of Orange folks have their initiative petition out, because their council turned a deaf ear to them, much as yours has. I've communicated with the city attorney for Corona, actually, at some length, and given him a lot of materials. But if the political winds are not blowing in your favor, you need to go the initiative route. The ballot box would be your remedy. What can you do in the meantime? Well, you can't do much if you're not in a position to pass laws. If the city council is pursuing an ordinance, they can do things like moratoriums or rent freezes, which have to be done very carefully to be done right, or else you have constitutional issues that could result in litigation against the jurisdiction. But you can't do that on a ballot initiative, okay? So I would just say that if you still have those kinds of abuses going on, it certainly, and hopefully if you communicate it right, will aid in your political campaign, because you'll have more and more examples of why we need to get this passed. The only other thing you could do is a rent rollback, and that's even more risky. And I'm not aware of any rent rollback that's ever been done on a ballot initiative, in my experience. But you know, when you live in a very conservative property rights jurisdiction, we all understand how tough it is.
Thank you.
Just to add one thing, if you go the initiative route, make sure you have a competent attorney draft the proposed rent control ordinance, because I've represented numerous cities and counties defending their rent control, park closure, park conversion ordinances, and the hardest job I've had is trying to defend some ordinance written by a guy in his garage drinking a lot of bourbon that overreaches on every point. Can't defend it in court. So you want a well-written rent control ordinance that protects you, but you want one that holds up in court.
And I would say pick up one of Henry's packets that are over on the table. He has a lot of good information here, and he has his whole tab. And I would also say, as I've said to you many times in the past, if you're looking for something, call our office. We will point you in the right direction. Nothing is worse than getting an attorney who's just taking your money and you're not getting anything for it. So we would be happy to point you in the right direction. Sir, I'm really trying to get to the correct questions. Is it on this issue? It's on rent control? No worries, we can hear you just fine. Well, we'll repeat the question. So his question is, he's been trying for 9 years to get rent control in his park in El Monte. South El Monte, sorry. And he is trying to get rent control. He's not had any help. Bruce said that he will talk to you afterwards. And it goes to kind of the point that the gentlemen were making. If you can't get your city council to act, then you're probably going to have to go the petition route and try and get it on the ballot. Ballot. Thank you. And it is a very hard route. And you know, a lot of cities, they're not going to make it easy on you. And the 6,000 signatures is a lot of signatures to get, but it's by city ordinance, so it depends on what your ordinance says, and that may be different from city to city as well. Okay. Right. So you have to recruit people. You know, I come from the labor movement. You guys have heard me say this before. There are strength in numbers. That's how we beat corporations. So you have to get people in your parks to gather together. You might not be able to walk. You might be able to do something else. And then you find the people who are able to walk and get those signatures and have them do that. So it's a community effort in the park. So, but please talk with Bruce afterwards. Okay, thank you. This is a question on title. If someone is on the title, doesn't it mean the park accepts that person? What rights do we have if the manager is if the manager is harassing us, they aren't following the MRL? So there's a question that there's a person on the title title and the manager isn't recognizing that person?
Yes.
Okay. Gentlemen?
The issue in regards to who's on title and what you accept, it all depends on if you're on title as a legal owner and or as a registered owner. In most communities, they require residents to be on title to the home, and you don't have to be on as a legal owner because it could be a lender, it could be your brother, it can be your sister, but that doesn't give anybody else rights of occupancy other than who you signed in with on your residency documents, and they will make you be at least a registered owner at minimum. But it's your residency documents that govern who can be in the community. So just if you're on title and you're showing as a brother or sister to the person and you're just a legal owner, it doesn't give you rights of tenancy.
Yeah, that's exactly right. In my experience, there's a lot of confusion that mobile home residents have, or those who live in mobile homes have, that they don't understand the distinction that needs to be made between who's on title to the home and who is a legitimate, as we say, spaced in, not spaced out, but spaced in resident who has tenancy rights to the rented space. They're two completely different things. You could buy a mobile home and go on title, but that doesn't give you any right to live in the home on the space. To do that, you need to go to the office, get an application, fill it out, give them proof of income, have a credit check run, and be park approved. So a person may be on title and they may live in the home, but they would live with somebody else in the home who's the tenant. That person who's on title but not on the lease or rental agreement is what we would call an additional authorized occupant or a guest. And they're only there under the umbrella of the tenant. So they can't pay rent. For example, Dick's not gonna tell his managers accept rent from people who live in the home and don't have a signature line on the rental agreement because they're not a tenant. So you see, that's the distinction. So and I'm not sure what the rest of the question was, but that may have a lot to do with how that person is being responded to by management. If management's saying, well, you're not really the tenant. So.
And the other question was, what can we do when the management isn't following the MRL?
Well, that's an enforcement issue. And it may depend upon what part of the mobile home residency law they're not enforcing. But as this book says in the frequently asked questions, that if you call the Senate Select Committee office and talk to Stephanie, she'll tell you this probably word for word. There is no such thing as an MRL police force, okay? We wish there was. We wish that there was enough money coming from someplace that we could have people wearing cool vests and little badges and they could run around and enforce it. But guess who enforces this? One of the first questions I always ask at my GSML seminars, who enforces the MRL? Who? Look to your left and look to your right, because that's who does. And that means you have to do something about calling that into question, you know, sending, if it's on-site management that's not following, then find out who the off-site management company is. Send a letter to them. Contact the park owner, get the park owner's address. Go over their head and say, do you realize what's going on in your park? And if Dick, I believe you, I've known Dick long enough, if he got a verified letter, or a letter from me, let's say, saying your manager's not following the MRL, he's going to look into it immediately because he doesn't want the liability. And enforcement is a huge, huge issue. There's a lot of different ways to go about it, but assembling your facts, start a paper trail. That's what I recommend.
A quick one in regards to that too. Make sure, honestly, read this and read the questions and answers because it's really well written. It's one of the best things that the Senator's office has ever done is prepared this book. The thing about it is, though, when you read the California Civil Code, read the entire section. Don't just read one little pivot on one issue. You got to read the whole area because it goes into more depth in some cases. So the questions that you feel maybe are not being addressed properly maybe are. But again, as he suggested, every one of us has to post at your park office who the operating name and number is of who you can contact in case you have an issue, in case that's not being resolved by your on-site manager. We're all supposed to have a posted sign it in regards to who that person is. And as he suggested, like if those letters ever get to us and stuff, I guarantee you they're responded to. Is there loopholes in the law? I think everybody can interpret it different, I think is the real issue, is the interpretation thereof. And I think, you know, the people that you see sitting up here, we all have grown up with it over the years. So we probably understand it of what the intent was when the law was being passed. So we probably know it better than most people. But that is the biggest problem. We have people out there that are interpreting this that honestly want to do it just the way they want to do it.
Before we take the next question, our mayor from the city of Ontario stopped by. Mayor Lynn, would you like to come up and say hello?
Do I need a microphone? Yeah. No, I'll go into it. Is this okay? I'll stand way over here. Well, good afternoon. Almost afternoon, all right. But I want to thank our senator for being here today and taking the concerns that you all have and also passing out some very valuable information about the mobile home issues and industry in our city and in other cities. There's some others who are here from anybody else representing another city?
Long Beach.
Well,
We have quite a good following.
Daisy, can you get her card and bring it up to me, please?
It's gonna get better.
Right. Yes. And
Long Beach.
her card. And also, how many of you here are Ontario residents? Just a couple? Okay, good. I can leave. No.
Because a lot of them aren't my constituents.
No, and you know, that's how you know that when you have somebody who's elected, good and elected to a position that cares about people no matter where you're from. And especially at the state level, like the Senate, I'm happy. I was just telling somebody else, you know, I ran for this seat years ago, but
Not against me.
not against Connie, didn't achieve it, but I'm happy to see Connie in it because I know that she's somebody who cares about people, and that's what mattered most to me. It wasn't whether I won or lost, if it was against somebody like this. And so I'm very pleased Connie is in this position. I used to be in the meat cutter, I'm not in the retail clerks union and the meat cutters at one time. So we kind of have some connections from the past, all the way back into the 70s. But I've been a union person in my past life also. But besides that, I've also been someone who's been very concerned about the living conditions and lifestyles of people, no matter what you're in, whether you're in an apartment, a mobile home, a single family dwelling, or even a mansion. It doesn't matter. People are people. We need to be very concerned about everything that affects them positively and negatively. Most of the things that happen.
You're fine, it just kind of takes it.
Yeah. Most of the things that happen, especially with the mobile home industry, are state level issues and kind of pass through to the city, every card. They're pass throughs into the city so that we are really doing what the state tells us to do about it. And so that's why it's so important for her to be here and with others. So the good thing about this today is that you have the right level of government. You know, folks, that's the problem. Oftentimes people do not understand the levels of government. So people will call me and ask me, as the mayor of Ontario, if I can get their son out of the military or daughter. And I'm like, no, I can't do that. Or they'll ask me if I can get a principal of a school in or out. You know, schools are another level of government, not state. And so in this case, we have the right level of government right here, right now in front of you on the issues that you have. And of course, we're going to work hand in hand with her. I wanted to make sure that Karen Spiegel was introduced. She is a council member from the city of Corona. And she's driven all the way over here to make sure that her city is represented well, and that she has all of the knowledge. So here's what I'm going to suggest to you. Besides just thanking you, Connie, for being here and taking the time, but you have the right people in front of you. So make sure that you take names and cards and no prisoners, okay?
What's your name, Mayor?
Are you from Ontario?
No.
Well, then you don't really know. What? Just kidding, I'm just kidding. I'm just kidding. My name is Paul Leon. I'm the mayor of the city of Ontario. So I want to thank all of you for, the other thing is that you're here. Resident apathy, voter apathy, all of these things are very frustrating to me because I think that it's important that we, the people, speak out and go and represent ourselves. When you send somebody else out in front of you, whether they're elected or just somebody that you say, you go do it, that just doesn't translate well. You know what I mean? It's best if you are here speaking up for yourself, learning for yourself, and I appreciate that from all of you. Thank you very much for being here. If you go to turn on your water and it doesn't come on and it's a problem in the street, call Obama. call Connie.
You could call me, I would say call Paul.
Yeah, that's the point. Your local elected officials were mostly responsible. When people ask me, what is it that I'm responsible for, and I say it's not to get your kids out of the military or something like that. It's to make sure that the infrastructure and the safety of the city are at top levels. So your streets, your gutters, all of those things, to make sure that we design the city to be good for you. That's the way I see it. That we put in place all of the things that make a city a good experience for you to live in. You get it? So if you do not pay attention to who you're electing at your local levels, you can end up with some challenges, let's just say. Some challenges. And do your best to research it. Unfortunately, it's the other thing, Connie, is that people ask me all the time, how can I know who to vote for, whether it's the president or the local level? You know, at these state and presidential levels, you get a lot of media filling you in with information. But at the local level, there's hardly anything. And so you do have to read your newspapers, and then the flyers, I got to tell you, the flyers can be, they're skewed. They're misleading, they're skewed. If I put out a flyer, do you think I'm going to put a bad one out on me? So, and on the other hand, if someone puts out a flyer on me, do you think it's going to say anything good about me? So you have to be very careful about that information too. And so social media is a good way. You can see what people are doing in social media, but don't always trust Google because some stuff people put on Google that isn't true.
All right, thank you, Mr. Mayor. All right, our next question: can the park charge a fee for each person if you own a mobile home? So what I'm guessing is I own a mobile home and maybe my husband, my children live with me. Is that what you mean? Can they charge a fee for the extra people that live there?
Or if we have a renter?
Or if you have a renter?
I think the question is whether or not a fee can be charged for guests, and the answer is yes, but not immediate family. So immediate family is defined in the code, but other than immediate family, a fee can be charged for guests. I've never heard of a park charging a fee based on the number of people who live in the home, independent of the guest issue. If there's typically a base charge for the space, And then if you have other people staying with you, the mobile home residency law does allow a guest fee. It doesn't stipulate how much.
If you own your own home, why can they say that you can only have one person, you can't have that person, or we're going to charge you money for that person being in your home if you own it?
Well, but you don't own the land that the home sits on.
But that land that the people are going to be sleeping in.
Well, I'm not meaning to get into an argument with you because I'm on your side. I represent residents. But I'm just telling you that the mobile home residency law, this state law, allows a park owner to charge for guests. And the rationale, I believe, is the more people that live in the park, the more the infrastructure of the park is going to be used and potentially impacted. And a park owner has an interest in making sure that the infrastructure is not overtaxed, if you will, by large numbers of people. There are local housing elements that also govern the maximum number of people that can live in a home. But beyond that, the charge, which I think would have to be a reasonable charge, it couldn't be confiscatory, is allowed, but not for immediate family.
There's also one other condition. If you're a single person, you can have one other person live with you without any charge. So you automatically can have one other person live with you without a charge. The issue of charging for non-immediate family members is, again, one of those cases, as he suggested, sometimes it has to do with the utilities, its systems, or whatever. Basically, you're going to find most mobile home communities allow 2 people per bedroom plus 1. If you're wanting to have those extra persons live in your home, that's one thing. If you're renting out rooms, be careful, because it's becoming an issue. This new, I don't know, what's it online, what they do?
Oh, Airbnb.
Airbnb. There's going to be some laws that do that where they can rent out rooms on a daily or a weekly basis. And so there's going to be legislation that comes down in regards to those things. But again, in most communities, in fact, a bunch of the resident-owned communities themselves have restrictions in regards to the number of people that can live and reside in a house, and they just don't want you to let in everybody and anybody. And also, even though you may have a guest, they still have to complete an application for residency. Doesn't necessarily mean they have to qualify financially, because you have, but we look into their background, prior residency, and their ability to meet current rules and regulations.
Sue, is this on this question?
Yes.
Go ahead.
I was wondering, I have my son, and he's on the paperwork, you know. If he gets married and brings his wife in, does she consider to be a guest or family?
Good question. Her son lives with her now, and if he gets married and his wife lives there, is she considered to be a guest?
No, she becomes immediate family. She becomes, but again, there's a lot of people that are moving people in and saying, well, it's my fiance, you know, so it's the issue of, you know, are they legitimately married? And then does it involve a child? Does she bring a child with her from a previous marriage or something? That child is also then immediate family.
And can the park charge you more on your rent?
No, if your son on the agreement right now? No. Who's on the rental agreement?
Yeah, he is.
Okay, he's on the rental agreement, so his wife, so no, they cannot charge you. Okay?
All right, next question. Yes, ma'am, on this issue?
Yeah, the reason I'm speaking is because it does affect me. I've lived 9 years in Friendly Village Mobile Home Park in Long Beach, and you're right. The first one is free. Okay, they cannot put a guest fee on the first person you have, not family. All right, MRLs. I have 2 other people that either, I don't know, somebody told me they would be homeless, all right, so I got them in my mobile home. So I'm paying a fee, and I asked them, how much is it going to be? And they said, it depends where you're at. It could be $25 over here, it could be another sum over here. So I'm paying $150 guest fee for each one. That's $300 a month. Now I'm saying to myself, I live in Long Beach. I don't live in Beverly Hills. I don't live in Lakewood. They can charge me even more if they feel like it. So how do they get away with that?
Well, the answer...
And I'm the only one being charged in the whole park.
Ma'am.
Nobody else is being charged except me.
Ma'am.
I'm being harassed and discriminated against. And I've written to the ombudsman and I've asked them, I don't know how many people I've already written to. Okay. And Nobody helps me.
Let Dick answer the questions that you asked, and then we can talk about afterwards your personal situation. Go ahead, Dick.
Your personal situation, it all depends on the residency documents that you've signed, to be very honest. It has to be in your residency document that you sign in regards to what that fee will be for an extra person. So again, you have to go back to what you signed and agreed to. It may say $50, it may say $150. I have no idea. Every park is a standalone. In most cases, I've not seen anybody charge $150 ever, to be very truthful. But again, in most cases, you just need to look at what you signed as part as your residency documents, and that will dictate what they can charge. And the other thing is too, did you register those people with the park? And because I would be requiring that.
And I would add that regardless of what's in your rental agreement, the fee has to be what's called a reasonable one. And that's a very subjective word, isn't it? Reasonable. What's reasonable to somebody is not reasonable to anybody else. And the only way you can establish that is by getting into court, which I don't know if you could do this through small claims, but it's worth a trial. Not a trial. Might be worth a trial in small claims. But again, the question becomes one of reasonability. $100 per person per month might be unreasonable. And the fact that it's location sensitive makes it sound like there might be something else going on. I'm not sure. But anyhow, my sniffer starts going when I see something that's kind of irrational. But that's the way you'd have to attack it.
Might be a good idea to pick up one of Henry Kenner's packets, ma'am.
You know what? I will read it.
Yeah.
But it's not going to do me any good.
Okay.
Because like you
Next
said,
question.
you're a lawyer to get in court to really win.
He is a lawyer. He is a lawyer.
I don't have the money.
Ma'am, you don't need a lawyer for small claims.
Say it again.
You don't need a lawyer for small claims. In fact, you can't have a lawyer for small claims.
I was just going to say that's why small claims court exists. We tell our GSMOL members that small claims may be a very good option for you. The way that I think a court would determine, a small claims court judge or a regular superior court, whether a guest fee is reasonable is whether it amounts to a penalty. That's the way that late charges have been construed by courts. If you're late on a payment, and let's suppose your payment is $200 a month that you're paying for. The late charge says if you are late on a payment, you have to pay $100. Does that sound reasonable? No, because that's 50% of the payment itself. So if it's a penalty that they're exacting, that's typically going to be unenforceable.
Ma'am, right here. Yeah, no problem.
My granddaughter lives in she is on the title, but he doesn't consider her a resident. Do I have to have a resident?
My granddaughter lives with me, and she's not on the title. She is on the title,
But not on the lease.
but not on the lease.
You two of you live together?
I raised her. Yeah.
Are you in a 55+ community or something? There's some other, it's an all-age community? An all-age community, and if your granddaughter is entitled with you, there should be no charge at all. And the issue about, being on title, and also you want her on the rental agreement, because if something was happened to you, then she would have the rights to residency. So if I were you, I would get her added to your residency documents, if at all possible. Because that gives her the right of continuing occupancy.
Manager bring her on because she wasn't employed.
Yeah, she has to qualify, but she has to qualify. I mean, one of the issues about whether you can add somebody in, it all depends on age. Once they turn 18, how old is she? Over 18? She's 20. Okay. Again, it begs the saying, do they qualify or not? Could she reside there and be able to make the rent if you weren't available? Okay. Then I would then reapply. Just ask for an application and ask to reapply. And they then will have to either deny that or approve it. Okay?
Hey, if you have somebody there, they raise the rent.
Sir, everybody else is raising their hand. Okay, that's okay. I'm going to take you, sir, and then we're going to go to the next question because I've taken a lot from you. Okay, go ahead. Go ahead, sir.
Is a son-in-law considered immediate family? Our park charged the son-in-law of a daughter who lived in with their parents. And previously, in the MRL, it didn't state whether a son-in-law was considered an immediate family. If that's the case, I think that MRL needs to change. I mean, if you're moving your daughter in and you say, well, your husband can't come unless you pay for him, there's something wrong there.
Currently, son-in-law, daughter-in-law is not named in the MRL. However, there would be, I think, precedent for that, similar to under Proposition 13, parent and child exempt transfers include the spouses of children. So that's not a bad idea, Carl.
I have a really good question on this issue.
Okay, quickly, please.
You know,
Got one more question.
the MRL was good back in the 90s and back in the heyday. But now, when your rent goes from $400 a month to $1,700 a month, and you're looking for somehow to pay that rent, because your paycheck didn't go up that high, so you ask people to come in your house to help pay the rent. But you can't have that unless they're family. So you end up losing your home because you're forced to get people to help you pay the rent. So the MRL protects the owner, but not giving them the leeway to have people stay in the house to help pay their rent. So they don't do that, so they lose their home.
Well, that's not always the case too. I mean, there's certain owners that maybe take that approach. There's other owners that accept that stand, that understand. One of the things, we have a park in over at Vista in Azusa. We're next to the colleges over there and the Azusa Pacific College, and we changed the age limit to 55-18 so they could have somebody move in and help us purposely.
I'm going to bring it up Corder Scott. You know, hundreds of people lose their homes. Hundreds. Not thousands, but hundreds of maybe even thousands because they can't pay the rent.
So what
We're
you're
asking for help from other people to help pay their rent before they lose their home.
Update the law is what you're
Well,
asking.
update the law. I mean, we're talking about loopholes. Who knows about loopholes in those MRL? Do you know any loopholes in MRL that you know of?
We know of loopholes.
Okay, yeah.
I think that's a...
You said there are plenty of loopholes and everything.
And the reason I say that is because people, to what Dick said, it's interpretation.
Right.
So the problem is you either negotiate something or you make it a law, and then people find a way to get around it, and that's what's called a loophole.
Right.
So nothing we can do is ever rarely is ironclad. So I'm going to move on. Okay, on this same question, I live in a 55 or older park with my son who is 33 and he has a disability. Would he be kicked out if anything happened to me?
The answer is protected. So he would in fact be able to stay in the community.
You're breaking up.
Sorry, Dave.
Yeah, we've got.
Can I talk long enough for you to hear it?
Yeah. Okay, all right, 798.21, no rent protection for NPRs, non-principal residents, not fair, as they pay taxes, spend money in the state, and can have rent raised at the park owners within. Or just talk loudly.
I was watching that, I wasn't listening, sorry.
Well, I think it was not a question as much as a comment that 798.21, which is the exemption provision, where there's a non-principal residence, is unfair. I mean, Dick obviously would have an opinion that may differ from me about that, but the reason, as I understand it, this code section was enacted and it was passed during a time when I was not GSMOL counsel, so I wasn't involved in the hearing. But the park owners are saying if somebody owns more than one home, it's not fair to protect more than one home under rent control. That you should only protect your primary residence and not multiple other residences. The problem that we run into is with the snowbird population. The people that have more than one home, they use more than one home as a principal residence, but they do it only during part of the year. And although park owners have tried to expand this and make it far worse from my perspective, we've actually, the resident community has held the line, I think, pretty well and kept the language the way it is. And there are exceptions to this. You know, if you are unable to rent your home out, if you're trying to sell your home, then this does not apply. But that's the theory, is
Yeah, that's the key. I mean, one of the things is if you have a rental agreement that doesn't allow you to sublease your home or rent your home out, then you cannot apply, an owner can't apply this to you in that reference. And we also then have to be able to prove that you have a primary residence somewhere else in the state of California. We see this predominantly with a lot of people that live in the Central Valley that have houses over in the beach communities along over on Los Osos and San Luis Obispo and those kind of areas where they actually have second homes and their primary residency is over in the valley somewhere. And so we don't feel that they should be able to take advantage of rent control on a beach house that they come over to on weekends or periodically. One of the things that's caused the biggest problem is the people that are trying to sell a house somewhere else and then they go and buy the manufactured home so they have a place to go to right away, and we give them like 90 days in that transition. So if most owners will be at least reasonable about it, but we have to prove that it's a second home. We have to give you all kinds of notice that you can then take all kinds of steps so this doesn't apply to you. So, you know, understand this isn't cut and dry for a park owner to be able to do this. So it does, there's all kinds of steps that we have to do before we can apply it.
And in the back, was this your question that I read?
Yes.
Okay, stand up so we can hear you.
But that just.
Oh, no, I was actually just the lady in the very back, I'm sorry.
Well, that one was my question.
Oh, was your question? Okay, go ahead, sorry.
In the Coachella Valley, we have quite a few Canadians, and it's quite obvious that they're Canadian, so therefore, our park didn't have to prove that this was not their permanent residence. And everyone, and some of them went up to, and I realize for many parks it isn't a difference, but up to $200 a month, because they were being brought up to a certain rental.
The current market rent. What's taken place is in a community like she has, we do have people that are from out of state, and that's an easy, that doesn't fall under this because we know for a fact that it's the second home for somebody that's out of state, and we're suggesting that they shouldn't have the protection of rent control if they have two homes. The issue is in California, and that's where all the arguments come. Do you have two homes in California? And basically the way to prove that is you take a homeowner's exemption on the other house, and if that's your primary residency, it's proven and you're out to lunch.
Well, then it should be stated as that, because this does not state it, it just says NPR, non-permanent resident.
Okay, thank you.
Can something like that, can something be taken care of then, so that those people are not penalized?
Well, I think it's, as she said, that's something that's got to be added to the California Civil Code, so there's more clarity to it, and that's not a bad idea. From both sides, by the way.
I made a note. And the lady in the back that I
I guess the question is, basically, the answer is no, they normally could not ask him to vacate unless there's some special condition that you have in dealing with a city-owned park. The issue in regards to, that's what they call the 80-20 rule. There's 20% of your park can be used for special agreements regarding handicapped people or other reasons. So that's why they have the 80-20 rule for 55+ communities, just for that specific reason.
Okay. And is it on disabled people living there?
No, it's on the principal residence.
Okay, we got a lot of questions, okay? We only have 45 minutes left, so I'm going to keep going, okay? But we're going to stay as long as we can, but I want to try to get to everybody's question. Do you have one in here? Real quick. Okay, no. The park owner asked for the title to each house, but many of the homeowners don't have a title because they owe money from taxes. How could you help these people get the title?
See, probably this is what we're talking about. In the state of California, how many houses, what percentage of houses doesn't have a title? 30%? There's probably 30% of the houses that aren't properly titled in the state of California right now. It's a real problem, guys, and you gotta try and get this cleared up now before it even becomes a worse problem. Because
and you think when you say that they need to get it cleared up, who do they call?
HCD, and that's one of the issues that we're running across when we conduct our mobile home park maintenance inspections. Each time we hold a pre-inspection conference with the park owners to discuss the inspection process, we are requiring a list of residents and any information off their manufactured homes or mobile homes, because it did indicate about 30% of the homes in California are not properly registered. And that's how we're going to attack this issue, if you will. Try to get everybody properly registered. Now, there used to be a law that was repealed, back in 1991, I believe, where it required the park owner maintain a copy of each of the residents' registration. That law was repealed. I don't know why. It should have, because now we're running around across this problem here, where we have most of the residents are not properly registered, or we had 3, 4, 5 different people that have since then have purchased a home and it's not properly registered. So it creates a big problem. But we are being proactive now in that we are recording all the residents' names, and we're cross-referencing that information with a registration and accounting office in order to get it properly registered.
We also have pending legislation that's been in the works for about 2 years. I think it's Assemblyman Chow, AB 584. And the idea is to have, what's the word I'm fuzzing on the word, where you forgive the property tax payments on a one-time basis to encourage people to come in and register current, and the counties, which are also involved in the negotiation, are going to have to agree to forego some of those big, huge backlog property taxes. Amnesty is the word I'm looking for. It's an idea that would provoke or provide amnesty for folks who are in that situation. You say, hey, I didn't cause this. I ended up buying this home, and now I can't get a good title. And it was because of people before me, maybe more than one person who did that.
See, I think it's, as Sal said, we used to get a copy of your registration every year. When you paid your registration, we got a copy of it. There was a copy that said park office. We should put that back in the law, that we get a copy. I mean, what's it take for the state to add a carbon copy? I guarantee you the park owners would be glad to pay a fee to do that, because we have to run title checks all the time and everything else. So if we actually, all of us had that ability, we used to have to fill out a form even before that, the park owners, and keep track of every house in your park with every legal owner's name. So when they came in to do an inspection of the park, we handed them a list. I think we ought to go back to that too. And I, as a park owner, would strongly support that.
I made a note of that, and I just wanted to, on the bill that Bruce was talking about, it's moving along very well. We just voted on it in Senate Transportation and Housing this week, so it's been through the Assembly. It's now going through the Senate Committee and go to the floor of the Senate. If it gets on there with no amendments, it doesn't have to go back to the Assembly, and it will go straight to the governor. So our hope would be that the governor will sign it. I'm going to keep moving along. I'm sorry. I'm going to keep pressing because I have to leave for another event in a half hour. I need to update the definition of RV. I found this to be a problem as well. Park models are not the old RV by definition. They are attached just like manufactured homes. They don't move from park to park. They are in parks with no rent protection.
That's not a true statement. They are not affixed like a mobile home, so they do not, and they're less than 400 square feet. They're 399 square feet, so they are treated as the same as an RV. Park models are treated the same.
So I have a question. In the parks that I've toured, and I see an RV that is clearly not ever going to go anyplace again unless it's on a tow truck, and things have been added on and built on.
The cabanas and everything, yes.
Yes, and what do we do about that situation?
The definition of recreational vehicle, park trailer, that definition was changed back in 1993, where recreational vehicles were for temporary or emergency purposes only. That language was removed from the law, so now they can be permanently, really, in terms of living year-round in these RVs, whether it be a park trailer or a fifth wheel. They're both the same, although built under different standards, different ANSI standards. A travel trailer, a fifth wheel, motorhome are built under different ANSI standards. A park trailer is also built under an ANSI standard, the ANSI 5C. Just different standards, but they're both considered recreational vehicles. None of those type of units can be permanently fixed to the lot. Okay, so the question was what now?
But the accessory structure.
Oh, and accessory, I'm sorry. Accessory structures, there's some prohibitions as a type of structure. You can construct adjacent to an RV. We will not allow a garage, we will not allow a cabana, unless the park trailer or recreational vehicle was located in a mobile home park. If it's located in a mobile home park lot, then you can't construct accessory structures. But on a recreational vehicle park, you may not allow the construction of accessory structures, except for decks and that type of thing, awnings, but no garages, no cabanas at all.
See, and again, what you need to understand is, in the state of California, there's permits to have an RV park and a mobile home spaces. So if you go down to your park office, you can look up on the board at the HCD permit, and it shows how many lots are either mobile home lots and or RV lots. And if they don't show as mobile home lots, then you can't build on the accessory structures, as Sal has just said.
So you cannot build them on. I know it happens. Yeah. So you would have to complain to the mobile home park manager or owner.
Oh, well, you have a whole park, and they're all park models. And they have, the add-on rooms, they have garages, and park, so forth. And they are attached, so you all know it.
That sounds like you want it.
Senator Leyva have an inspection in Corona. To be more specific, can you inspect Corona West Mobile Home Park and Corona Low Linda Mobile Home Park? I personally cannot, but I'm going to ask a favor of my good friends from HCD and see if they can do that, okay? They're very busy. I kept them very busy this year, but I'm going to ask them if they will look into that. This is a very interesting statement, and I want to read it, and I want to ask the person who did it to give me their name and number so I can get in contact with you. It seems that one of the big issues of residents today is mobile home law enforcement. Washington State has a dispute resolution program managed by the Attorney General Office, also giving the office enforcement powers. It seems to be a successful program and solve a lot of problems, though it costs residents a fee each year. Can this work in California, and what are the pros and cons? On its face, it does sound good. So is that what you said? Yeah, I will look into that, and I will see if there's any, I don't know if you gentlemen have any comments on that?
The basic comment is there's a lot more spaces down here.
That's probably totally true.
In Southern California.
Thank you.
And so the issue about having the ability to do that is really kind of, we've looked into it before, and the state has passed on that in the past.
But I'll still look into it because I think it's interesting. So let's see what I can find out, okay? Carlos Viejo from South Alani. This might serve as assurance there. Oh no, this is an illegal business run or park, and the manager doesn't do anything about it because the business is named Lucy's Bubbles Pet Grooming and Spa. But I have a feeling Lucy's Pet Grooming and Spa is doing something else. So if you know there's an illegal business being run, what should we do? I would say call the police.
This is a touchy situation. It all depends. It's one of those issues where trying to determine whether somebody's running a business, does it require a license or not? You know, it's the same thing. Our operating permits tell us that we cannot allow additional businesses in our community to operate. So if you're trying to operate a business out of the community, that's one thing. But a lot of these groomers and stuff, they're portable. You know, they have the portable vans and stuff. They go out and do the grooming and stuff. So you would have to know all the specifics before you could comment to whether you could do anything about it or not.
I personally would call the police. If somebody's doing something illegal where I live, I'm going to call the police. Yes, ma'am.
In regards to the Corona West and Corona Leyva
Yes.
part,
Yes.
I would like to get a feedback on that because we need someone to start by this important property.
Right, that's
Having
right.
a lot of issues.
Yeah.
Okay, and I totally appreciate that. What we do, HCD, when we schedule park inspections, we have a certain criteria that we follow. And the criteria is that we're going to inspect the older parks first, the parks that we believe warrant an inspection, or parks where we receive the most complaints from. Okay, that's the criteria that we use to fulfill a 5% goal every year of park inspections. If you have issues within your park, you can certainly submit a complaint. Okay. By the way, I did provide some Mobilehome Ombudsman posters located in the back table there. As you know, the Mobilehome Ombudsman office is a clearinghouse for complaints. They will direct you to either the Northern Area office, Riverside office, or if it's a civil issue, they'll direct you elsewhere, or whether it's something under the city or county jurisdiction, they'll direct you there. But in your particular case with this particular mobile home park, if it's in such condition that would warrant an inspection, we will definitely schedule it for an inspection. But at the very least, you can submit a written complaint, be very specific as to the items of your concern, and we will address those.
I'm already working on my part, but for Corona West, nobody's helping them, and they don't want to help me. I'm an HOA, president of Gizmo, and they don't want to work with me because they threaten, and a lot of them don't have a immigration status level, so they don't want to, their fear, and they are a very bad situation. The way they lead is just horrendous. There's a gentleman that is paying $1,800 a month for rent for space. And you guys need to do something about it.
Okay, well, we're not in a position to enforce any issues with rent fee increases. We can only enforce health and safety issues within the mobile home park. Now, you as the HOA, you can provide us with a list of concerns or issues that you have in that mobile home park, and we will address those individually.
Other than rent.
Wait, sir, hold on. We have hand up first.
Yes, you talk about going and inspecting the park. Okay, you've inspected our park a couple of times and wrote them up for it, but yet you keep giving them extensions to fix it. Why I don't
So
understand
see,
that.
if you're reading my mind, that's the next question. So, on an activity report or violation and a 90-day repair, how many extensions does the owner get before there's a final closure, or what I know, the residents don't have to pay their rent anymore?
Okay. Yeah. Typically, we give either the park or the residents 60 days to comply. Okay. Now, in some cases, now the law, the statutes, the California Health and Safety Code has some latitude where it allows the enforcement agency to give time extensions because financial hardship, trying to get a hold of a contractor, or issues like that. And we look at it on an individual basis. Violations that present an immediate threat to health and safety, we will not give an extension. That's absolutely not. If it's an immediate threat to health and safety, we cannot give extensions on those. But on violations that consider an unreasonable risk to health and safety or technical in nature, we can go ahead and work with the resident, give enough time to comply. We also do the same thing with the park owner when they request an extension, or the resident or park owner may request an informal conference to dispute
You got the same park
violation.
owners that own several parks doing the same thing to several parks.
Well, we're doing that to all the parks.
Exactly.
Okay.
So why give them extensions any longer?
Depending on the circumstances, we're gonna afford you the same extensions as we do park and vice versa. It all depends. And the goal here is to get compliance to correct those violations.
And I think it's important what Sal said, because there is some frustration with how long does someone get an extension. The goal is not to close the park, because if we close the park...
We meet with the park owners, Sierra Management Corporation. We had an informal conference with them. We did issue a notice of violation. What they're going to do is they're going to, in fact, they're already contracted with a soils engineer who is going to look at the condition of the soils. We got ponding water. We have soil subsidence where meters are being lifted up, fire hydrants are being exposed.
We've already had a the water standing in the
Exactly. And we're aware of that as well. We are working with the park owners. They've already secured a soils engineer who's going to take a look and make a recommendation as to what the repairs are going to be. Now, this is not going to be something that's going to be taken care of real quick. This is a big project. This may entail removing some of the homes in order to backfill, compact, in accordance with the soils engineer's recommendations. So, they very well may have to move some of the homes out because 3/4 of the park is that way. This is going to be a huge project for them. It's going to cost millions of dollars to repair. We know that. And so, but we are working with the park. We've already had several meetings with them. They're on track. And we... Yes, we did work with the park in order to secure the soils engineer, the contractor who's going to do the work. We requested a time frame for all this work to get done. Now again, it's not going to happen overnight. It's not an easy project. It's huge.
And here's the problem. You guys are there every day, so you're living it every day. And yeah, no, I'm not convinced by that. That's why I'm saying that. They're trying to deal with your situation as well as hundreds of other parks where there's issues. And it would be great if we could assign 1 or 2 people to be there and fix it like that. Trust me, I have learned being in government now for a year and a half. Unfortunately, it doesn't work that way. But the best part is what Sal is telling you. They're aware of the issue. They're on the issue. They're negotiating. And I know you're rolling your eyes. I know, but like I said, you live there every day. They're doing the best they can. I mean, there's things that I wish I could address that I can just run out and fix right away. But we can't always do that because we don't have anything in our power. They're aware of it. They're working on it. Please, what you brought, please give that to him. Like some information that he doesn't have. But know that they're aware of it. I mean, I think the most important thing is that they're working on it. And you didn't just surprise them right now. They didn't know about it. So, but I understand your frustration because you live there every day. I understand. Well, that's the other thing, exactly. Because if it's not done right, then you get to where the park is closed, and then where does everybody go?
If we were to take any adverse action against the park, that means closing the park down. We'd have to suspend the permit to operate. That means the park is no longer illegal operating mobile home park. And so we don't want to do that. We want to preserve the park. We want the park to comply. We want the conditions to be repaired. And that's what we're after. We are in negotiations with the park owners. They are working with us. Like I said, we've met with them several times already. And again, it's not something that's going to be corrected overnight. It's a big, big project. And so, please bear with us. We are working with them.
Driving us out with rent raises anyway.
All right, so what I'm going to ask, we have 3 questions left. This is something that affects you all personally because that's where you live. So if you can ask some of those questions afterwards, we talked a little bit about rent control. Rent control is a big issue. I know
70. Pre-76 homes are built to a different standard, but again, there are parks that still accept those houses, so it all depends on the communities. Most of the newer communities will not accept pre-76 houses because they weren't built to a federal standard.
But, and I'm guessing this question is someone who is living there now? And, okay, and the manager is asking you to move it out?
They're saying I can't move it out.
They're telling them to move it, they can't be moved out.
I wanted to give it salvage before I surrender it to them.
Yeah, you can give the salvage.
They're saying no.
They're saying that
They told the salvage company no.
they're saying that you physically are prevented from moving it out.
Yes.
Did they give a reason? Did they say you don't have an insurance?
It can't be moved down the highway.
No, we can actually destroy houses on site. I mean, we really can. So there's no, they cannot hold you to that. It's none of their business. You don't need a legal counsel, right? I would contract with a group. There's companies that will do that, and I understand that. I'm just sitting here telling you. You can have somebody, like there's people that are taking these houses down to Mexico, right, legally, right, and they'll transport them. Just talk to one of those guys, and basically I would suggest you sell it to them for $100 or something like that, and have them take then the full responsibility of the removal, and away you go. Well,
what you're saying is no adverse action can be taken against her by the park owner for doing it.
not for removal.
Not for removal.
Now, I don't know if you have a lease agreement with them that obligates you. Okay, you have a tenancy. Okay, then you're fine. Because if you have a lease agreement, then you're responsible if they can't release the space for the term of the lease.
All right, very good, thank you. What can be done about the sewer? They know the time limit they have to get a truck out to drain, but they wait, and I'm thinking this is the manager, for it to overflow, and then the tenants are the ones that have to clean it up, and it happens 2 to 3 times a year, and sometimes it backs up in homes. Well, that sounds like a big problem.
Call my law firm, Alex Emmelsberger Taylor. If you got a bad sewage problem, we once drove by, we were driving somewhere to a park to meet with residents, and we saw a rotor-rooter truck. And the slogan on the rotor-rooter truck was, "Your crap is our bread and butter." I joked with my other partner, I said, that should be our firm. If you've got a serious enough sewer problem, it sounds like you've got a septic system, you're talking about the septic tanks being pumped, if I hear you correctly. And you have a, what? No, and it sounds like there's a bigger problem because if the septic tank's backing up, it has to be regularly pumped. Septic tanks should be pumped regularly. There's a buildup of sludge that has to be removed every now and then, but if your septic tank is overflowing all the time and has to be pumped, that means the effluent, the clear water that's coming out, is you've got either a seepage pit that's failing, it's not taking the effluent, or you've got a leach field that's failing. So you've got bigger problems with the sewer system if the septic tank needs to be pumped regularly, which obviously has to prevent spills. So again, that's something HCD would probably be interested in. It's certainly something that our firm would be, worth listening to and talking to you about the problem.
Okay, so, Dr. Henry, I know HCD has helped us have some parts in my district that this was a problem, and we were able to get it fixed.
You've got my brochure, it's got my card in it. That phone number will take you to our intake paralegal, Maria Ripa, and she'll be able to handle it.
All right, that was the last of the written questions. Yes, ma'am.
I have a question. On the MRL, there were 5 changes that were made in 2016. Who voted on this?
There wasn't any real major changes to the California Civil Code, but who voted on it?
Who voted on it?
That would have been all your state legislators signed by the governor, or they cannot change the mobile home residency law.
Okay, how can we as a community be invited to those meetings to discuss these changes?
it has nothing to do with the mobile home park. He's saying out on private property. I understand, but in most mobile home communities and stuff, which I suppose that things now are have to hook up to the sewer systems because they won't allow us to put in new systems. But it's very property too.
I think you have to ask to go to your city, go to the buildings, the permits.
Building department.
Building department. Yes. Yes, sir.
I appreciate Senator Leyva coming out this week. And what's her name again? Lydia, yes. Because I have about 6 experience like her. We had a organization. We organize the residents in our park. Then we receive 10 days notice, 60 days notice, and bring us to the court. And we try to get help from lawyers. And one lawyer said, don't fight. If you fight, you'll be vacated. But I know this is the United States. And we have the right to have our, we have our right. So we should fight because there's so many things happening there. The lady said $300 fine for 2 people. In our park, $450 for each person. The lady was fined $4,380 in once. So that's why we had protesting in 2013. And we organize people, we hope people get it together. You know, who enforces the law? People. So I encourage everybody, we need to get it together very open. And we need the lawyer's help. Fortunately, we have lawyer help us, right? Yes. Thank you. Thank you. Thank you. Go ahead.
I just want to, something that was raised by apparently some other lawyers said, you don't want to exercise your right because you get evicted. Let me tell you that, you know, there's a provision, not in mobile home residency law, but there's a provision in the Civil Code, another section, I think it's 1942.5, which makes it illegal for a landlord, and it includes mobile home park owners, to retaliate against any tenant for peacefully exercising his or her rights. So the law specifically prohibits a park owner from retaliating against you for bringing a lawsuit. And there's a case that's right on point, involves a mobile home park. And you can then not only sue the park owner for the problem you originally sued him for, you can also add a cause of action or a claim for unlawful retaliation. So it'll just make you more money if he tries to do it. It's not mobile home residency law, it's in another section of the Civil Code, 1942.5.
Well, I just want to take this question. Are you trusting up to this or retaliation on people waiting the park?
Did you call the police?
No, the police came and rescued me. Because I was sent to the hospital. Okay? And I got incarcerated 2 weeks ago because I reported the people they charged me with criminal 245 tickets. But I
company, you get the park owner's address, you go up the food chain. Because they could have liability for that protection.
So can we finish and then you can talk to me privately? Is that okay? Yeah, that would be perfect. All right, I just want to take one more question.
So, the park, you close the park, what happens to the home? Well, we're not in the business of closing parks. The park, I'm just saying it can happen. This guy goes to friendly park. You know, if they close the park, what happens to the home?
Good question. Requirement in the government code, you have to put out an impact report and address relocation costs to close a park. And then the question becomes, who's closing the park? Is it the park owner or is it the state? I had a complicated situation where I once represented the residents of a mobile home park down in San Diego on state trust lands that were leased by the city to a corporation. The state decided, or that under the state law, that the trust lands couldn't be used for a mobile home park and it had to close. So at some point, the park owner couldn't renew its lease with the city. Well, no one wanted to pay relocation costs, so the park owner says, we're not closing the park because we still want to operate. The city won't renew our lease. The city says, we're not closing the park. The state says, we can't renew the lease. It's the state. And so they're all pointing the finger. But then that will become a question if the park has to close. Someone's closing the park and someone's going to have to pay relocation costs under the government. That's my opinion.
I think he's hit it right on the head. And there's individual cities that have the relocation benefits, and some of those are reasonable. And they're trying to find places to move some of these houses just isn't happening in California because no new parks have been built, to be very truthful. There's very limited number of vacant spaces. The only vacant spaces in California are basically the Central Valley that you're going to find in. So the issue of that's why I say be careful what you ask for you might get it. The state trying to come up with repairs and maintenance of an existing community, you may have to be faced with relocation home, and there's no place to take them. And when you're sitting there saying, well, are they going to give me fair market value for my home? The answer is no, because that's not a requirement of the state law. State law says reasonable relocation benefits. So again, I mean, it's all up to your attorneys who you hire on how that's going to be litigated downstream. But again, in most cases, yes, when they bought that park, they knew that it was built on an old Agajanian dump site, right? But they didn't expect it to continue to subside and stuff. So can you sit there and say they knew, so they should be held totally responsible? That's the biggest issue. That park has been subsiding for the last 30 years, to be very truthful. I mean, I literally ran that park 35 years ago. Okay, and we had to put back in those days, we had to put the spa on a 22-foot pedestal to keep it from sinking when it was full. Okay, true story. It goes back that many years. That park has all kinds of methane gas collection systems that vent methane gas to the air. So everybody's known about that park for years. So it's not like it's something new.